The U.S. Constitution's First Amendment, Fundamental Natural Rights. The First Amendment to the U.S. Constitution was added on December 15, 1791, as part of the Bill of Rights, and recognizes that Americans possess 5 important freedoms and limits government interference with these rights. The First Amendment works differently than you might think. It doesn't grant rights. It recognizes natural rights and limits the government from interfering with those rights. The government's job is to protect these rights. The structure of the Constitution limits federal government based upon a revered legal principle the founders referred to in Latin. Expressio Unius est exclusio alterius. The English translation is, if you mention one thing, you exclude all others. By listing federal powers in the Constitution, the founders intended to exclude from government regulation any subject not listed. As the Constitution was being written and debated, the Federalists believed this principle limited government enough since the Constitution did not grant government power over speech, religion, or press. The Anti-Federalists worried that without clear limits, reliance upon a legal principle for protection of natural rights was dangerous. The debate resulted in compromise. The Constitution was ratified with a promise that a Bill of Rights be added. That's why we have the Bill of Rights, and a First Amendment that begins, "Congress shall make no law." The founders knew about religious persecution in Europe and America. They wanted to make sure Americans could practice any religion freely. They also knew that for democracy to work, people need to be able to speak freely and criticize the government. During the first Congress, James Madison wrote the First Amendment. He got ideas from Virginia's Declaration of Rights, amendment suggestions by the states, and European thinkers like John Locke. The First Amendment names 5 rights. Only 1 in 1,000 Americans can name all 5. Listen carefully to the text of the First Amendment and pick out all 5. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. The first right in the First Amendment is freedom of religion. The First Amendment protects religious freedom in 2 ways. The Establishment Clause stops the government from picking an official religion, and the Free Exercise Clause stops the government from interfering with how people practice their religion. This makes America different from many countries. England has an official Anglican church. Some countries are based on one religion, like some Muslim theocracies. Communist countries like China and Cuba restrict religious practices heavily. Religious freedom means more than attending the church of choice. It means freedom to live life in accord with personal beliefs without government interference. Thomas Jefferson put it this way: "Among our greatest blessings is the liberty to worship our Creator in the way we think is right." The second right recognized by the First Amendment is freedom of speech. This limits government interference with how people express themselves. This freedom includes expression of ideas via spoken and written words, art and music, symbolic actions like wearing armbands to protest a war, even burning the American flag as political protest. Generally, the government cannot restrict speech that tells the truth or expresses opinions. Not all speech is protected. The government can punish. Speech that creates immediate danger, like falsely yelling fire in a crowded theater, filing of false police reports, incitements to violence, obscenity and threats, lies that hurt someone's reputation, libel and slander. The third freedom in the First Amendment is freedom of the press. When the Constitution was written, the press meant newspapers and books. Newspapers were printed on wooden hand presses with each application of ink to paper requiring a pull of a lever and tightened with screw. Thus the ink was pressed on the paper. Now it includes radio, TV, the internet, bloggers, and podcasters. This shows how fundamental constitutional principles apply to new technology. Freedom of the press includes the right to publish information without government censorship or permission, protection for reporters' sources, rules against prior restraint, stopping publication before it happens. Fourth on the list of First Amendment freedoms is freedom of assembly. People have the right to gather peacefully for any legal purpose. The government can set reasonable rules about when, where, and how meetings happen, like requiring permits. but it cannot ban peaceful gatherings. This right also includes freedom to associate with others, the right to form organizations and participate in group activities. Remember, the First Amendment restricts government action. Private organizations generally can make their own rules about speech, assembly, or membership. Just as the First Amendment limits government in restricting expression, it also prohibits the government from compelling people to express thoughts or ideas to which they object. The fifth freedom in the First Amendment is freedom to petition the government for redress of grievances. The Declaration of Independence complained that King George ignored the colonists' petitions. We have asked for help in the most humble way, but our requests have been answered only with more injury. The right to petition was central to constitutional law and politics in the colonies and early United States. It is the First Amendment's capstone. The right to petition is unknown to most Americans, or if known, considered to be an extension of the first four rights, and not a right that stands on its own. The Petition Clause has distinct history and English roots different than other First Amendment provisions. The Petition Clause has roots in the Magna Carta, written in 1215, which provided for presenting grievances to the king and required the king to redress grievances within 40 days or risk rebellion. The Magna Carta's right to petition includes the right to wage war against government for failing to redress. In the American colonies, this ancient right became the act of submitting grievances to legislative assemblies. By the 18th century, Americans routinely submitted petitions to the local assembly. The original right to petition included a concurrent right to a response. The story of the Petition Clause is of a right that Americans have lost from its original meaning. The Petition Clause is worthy of its own study because its treatment ignores Chief Justice John Marshall's declaration in the case of Marbury versus Madison. No provision of the Constitution was meant to be without effect. The Americans' experience with British rule, including limits on religion, speech, press, assembly, and petitioning, directly impacted the protections included in the First Amendment. Originally, the Bill of Rights limits applied only to Congress. In 1869, nearly 80 years and a civil war later, that the 14th Amendment extended Bill of Rights limits on government conduct to the states with this opening phrase, "No state shall." The First Amendment's interpretation now covers more than the founders imagined by adapting its principles to new technology. The 14th Amendment extended the protection of these rights from state and local government interference. The Constitution and First Amendment acknowledge the natural law principle that government did not grant fundamental rights. The intent and design is to protect rights that are endowed by our Creator, as the Declaration of Independence announced. Can you now name all 5 First Amendment rights? Very few Americans can, but by now you should be able to recite religion, speech, press, assembly, and petition. Thanks for watching. Please like, share, and subscribe to Constitutional Soundbites and learn more as we delve deeper into the Constitution's impact on our lives. 1.25